My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and biometric reference databases. So biometric reference databases are databases that collect or have or store biometric information or have the capability to store that type of information that companies use. There was a recent case and a ruling in Australia from the Office of the Australian Information Commissioner related to Clearview AI and data scraping of identities or biometric information about people in Australia. This was a joint investigation, and actually Australia, of the two, between Australia and the UK, they're the only ones that have added a ruling currently. But people expect soon that the UK will likely have a similar ruling. So this ruling was that Clearview AI's collection of data of individuals in Australia, that it was a violation of the Australian Privacy Act of 1988. So this particular Privacy Act is very similar to things like the GDPR and kind of the UK Data Protection Act, where they're saying that individuals should have information about how their data is being used. This particular use of information in terms of data scraping has been a big issue that has come up in other court proceedings around the world. Probably Australia has been one of the biggest ones we're looking at. The UK, obviously, since they're doing this investigation, but also there's a case pending in the US under the Illinois Biometric Information Privacy Act related to this same issue about Clearview AI and data scraping. So what the Australian Information Commissioner ruled is that because the collection of biometric data by Clearview AI was a violation of the Privacy Act, they wanted Clearview AI to stop data collection of, or facial image or biometric collection of data of individuals within Australia, and also to delete any images or facial recognition images of those people within Australia. So this is a big deal. Not sure, I think there'll probably be kind of an appeals process, but people think that the UK government or the ICO will have a similar ruling, and this will also, I think, inform what's going to happen with this Clearview AI case in Illinois, because these are basically the same questions. Like, is it legal for this company to scrape data of individuals without their sort of knowledge or consent, especially as around the question of seeding databases with images of people who likely have not committed any crime. So there is a big debate now in the facial recognition world about the ethical use of facial recognition databases or reference databases. There are companies that argue that if you give let's say a law enforcement agency a database that has a functionality to capture those images, that those databases should be empty, and that the law enforcement agency should populate those databases with kind of known suspects or known images, so then it's not a situation where everyone's guilty until proven innocent. There's kind of a reason why data is collected about those people. So we recently saw, and this all kind of ties in together, that Facebook recently decided that they're going to delete billions of images of individuals that they collected on their platform. This is a little bit different than data scraping, because those images, there was some consent mechanism, obviously, because if you're a person who is on Facebook, you may have consented in some way to that particular use, way to tie the collection of these facial images to a legitimate purpose. And I think that's kind of the way that these cases will end up going. So the indiscriminate collection of facial recognition images is something that I think will be limited to a purpose in the future. That's it. Thank you.